I have appearances, please.
This is Brett Hill, the attorney for the plaintiff, Heather Downing.
You're muted, Mr. Petard. Can't hear you. Okay.
Can you hear me now?
Yes, sir.
David Petard for Carolyn
Mr.
Coffee.
Petard, I'm not going to make a big deal of it, but I know some of my colleagues would, that if you appear in a Zoom virtual courtroom, you should be dressed as you would in the regular courtroom. All right. I have looked at the docket, and my docket says we're announced for 3 hours. Is that correct?
That would be news to me, Your Honor, but I'm here as long as the court needs.
Mr. Petard, what do you think the time announcement is?
Excuse me.
Are you there, Mr. Petard? You're frozen.
Correct.
Correct. The announcement is 3 hours. Is it correct that the announcement is for 3 hours and you need 3 hours of the court's time today? Okay, well, let the record reflect we've lost Mr. Petard. Let's wait a minute and see if he'll come back on. While that's happening, Mr. Hill, I show that you've got a motion for scheduling order. I show defendant's motion for summary judgment. My docket says motion for sanctions and motion to dismiss, although I couldn't find those in the file.
Okay, absolutely. Sorry, sometimes this case overwhelms me a little bit by what's being filed. So let me start with, we haven't filed anything. Looks like Mr. Petard's back.
Okay, we'll let Mr. Petard get back on. Well, you actually, I show that you filed a motion for entry of docket control order.
That's right. We've been trying to get a DCO in this case since we didn't get reached in October.
Well, let's wait. Hold on. I started this. Let's wait for Mr. Petard to turn on his camera, please.
He's trying to work his computer.
I may come up. I may just use Carolyn's computer, Your Honor, where she's connected. I may just use Carolyn's computer.
Okay, if there's two, I'm getting a really bad echo, and I think that means that there are two computers in the same room, which will cause an echo to Zoom. So one of them needs to be turned off, but neither of you have your camera on. And now you're both, Mr. Petard and Ms. Coffee are both muted and don't have a camera on. It makes no difference to me which computer you use, but we can't proceed unless I can see who I'm talking to.
Well, they're starting their camera up, Your Honor. I was disappointed. Last week we asked if he wanted to do it remote, and he wouldn't respond. So then we just had to say, we're coming. And I made reservations for a nice restaurant for me and my mom. And then yesterday we got the message that it was Zoom. My mom had bought like a new outfit. I was like, Mom, we can still go.
Sorry about that.
No, but it's not y'all's doing, Your Honor. Obviously, it just is. Every time I try to go to this particular restaurant, something like that happens.
What restaurant is it?
It's Daidue, just right there on the east side of town.
I've been to Daidue. It's good.
Okay.
Okay, now Ms. Coffee's computer is unmuted. All right. I will. So I'm going to change your name.
There.
Okay, the other computer must be turned off because I'm getting an echo.
Turn this off completely.
My whole computer.
Yeah, turn it off.
Why don't I just wait? This is frustrating. I show let the record reflect that both Mr. Petard and Ms. Coffee's computers have logged off of the Zoom. So we'll wait for another minute to see if they can get back on. There's Mr. Petard. He's Mr. Petard, I see a computer now logged in. Why don't we start with unmuting yourself, which is the bottom left-hand corner of your screen. there's a little icon that is a microphone. Click on that. Mr. Petard, I need to know that you are hearing me and that you're going to be able to get a computer up and running so that we can conduct a Zoom hearing. Mr. Hill, might I ask that do you have that phone number for Mr. Petard?
I'll check right now.
If you do, I might ask you to mute yourself and call him, see if we're good to proceed. I'll give this another, 10 minutes or so, but if we can't get this up and running, I'm afraid you're going to have to reset.
I'm doing it right now. I just found the number.
Thank you.
2,000 years later.
Hey, Ron, he's on the phone. I just want to make sure before I'm just unmuting myself. It's not going to cause a weird feedback. But
Okay.
he is
Go
here.
ahead. Go ahead and
David, what's going on?
I think the possibility that I'm not close enough to my router, I'm going to take my computer and to the other room and see if that makes a difference.
Okay, well, if it doesn't
But
work out,
Mr. Hill, what did we hear? You're muted.
okay, sorry about that. He said that he was too far away from his router, maybe. He was going to get closer to his router, retry it. And then I said, if it continues not to work out, just to give me a call back at my office number. And then I called my receptionist to let them know downstairs to directly transfer it to me. Because normally they see me in hearing, but I said, just transfer it and we'll get it sorted
Okay.
out.
Thank you. Well, it's strange because that second computer was working. I don't know why they turned it off, the camera and the.
Got some thoughts about that I'm not going to share right now. But
Probably inappropriate. Yeah, we won't do that.
however, I will say I was hoping that we'd be less than 3 hours because my wife's in trial right now and I'm trying to get over there, see her for a minute.
Are you in Houston?
I'm in Houston right now in Montrose, looking at Hawthorne Street.
Okay, here it is.
Okay, there are two computers on that is causing a terrible echo. That's not going to work.
Did that fix it?
Say something else.
I think my phone is, let me take my phone off. Can you hear me now?
Yes.
Brett, I'm gonna leave the meeting and rejoin it if that's okay. To see if
I'm
that
going to give you about
cures
another
this
5
problem. I don't know what
minutes.
the problem is. Oh, I'm calling
Mr.
again.
Petard,
No, no.
if you can't get your
Mhm.
technology
Now
figured
where
out in the
am I?
next 5 minutes, you're going to have to
Now I
reset.
can't even hear them.
You can't hear me?
Why did we get both of us?
It's 2:24.
Connect me to Brett, please.
The record reflects it's 2:24. Mr. Petard is not able to get his technology working and is an apparent on the screen. It shows, I see Mr. Petard and Carolyn Coffey. That's what the tile says. They apparently can't hear me.
Yes, we can hear you.
But we don't see this on the screen.
I see you.
And can you hear me okay?
Yes.
Okay. We can be trying, but anyhow, we can,
All right, good. Then good. That's fine.
okay, I'm using,
You're good?
I guess.
Okay.
At least if you can hear me, then that's good enough, I guess.
Okay.
Okay, now, I hope this doesn't take that much time. I heard you speaking about the time, Mr. Hill, and I'm not wanting to take more time than necessary.
Well, let me start, Mr. Petard. I can't rename you. I was going to rename your tile. My docket shows that someone has set and announced for 3 hours, and that what I've got set is what I can find in the file is plaintiff's request for a scheduling order, defendant's no evidence summary judgment on causation. I can find both of those pleadings. my docket says there's a motion to dismiss and motion for sanctions set. I do not find those documents in the court file. So what is it you think is set here today, Mr. Petard?
Motion to dismiss for want of prosecution.
When was that motion filed?
I believe it's May 4th, 2023.
Okay. I found that.
And a motion for sanctions for discovery abuse. Not sure when that was filed.
Okay, what is that noise?
That's going to be someone outside doing yard work.
Okay,
It's,
if it's
while
yard
we're
work,
late.
I wanted to make sure it wasn't anybody.
we can tell them to stop, though. It's honestly one of the most annoying things. I'm going to tell them to stop.
I see you.
Look, I've got a sign-in thing here.
All right, my staff's heading out there to tell them to stop using it.
All right. So I see on May 4th, 2023, plaintiff's response to defendant's motion to dismiss for want of prosecution. I've yet to find defendant's motion to dismiss. Well, y'all are here prosecuting it, so why would I dismiss this case? It looks like there has been some significant action in this case since you filed your motion to dismiss. So why would I do that, Mr. Petard?
There's no significant action to bring this case to trial. Right after I was asked about a trial setting, the assistant for Mr. Hill communicated with the court after almost a year had gone by with nothing, asking about the status of the case, and they were told it was not set, so she wanted to set it. That's when I filed the motion to dismiss for want of prosecution. Since that time, and up until the date of the trial, they set it for October the 2nd. Nothing happened to bring it to a conclusion before October 2nd. And when the 30-day period for the pretrial deadlines set in, none of them were met. The trial was not announced. And the assistant for Mr. Hill asked me for a mediation date in October 14th, which is after the trial date. We didn't get reached because we were so far down on the docket, but part of that's because the trial was not announced, or it could have been, I'm not sure. So,
well, hold on, let me stop you. You could have announced it. Why didn't you announce it at the setting? And then you wouldn't have bumped to the bottom of the docket.
Because I think that would be inconsistent with my petition to dismiss for want of prosecution.
Right.
Now, since that time, there was no effort to compel mediation anyhow. I don't think mediation will work in this case anyhow. And I've been long on that position. They sought a discovery control order that opens up discovery. This is 2024. This case was filed in 2020. If they were prosecuting this case adequately and they set it for trial, they wouldn't need further discovery.
Okay, hold on. Let me stop. I show that this case is now sent for October 19th, 2024. Yes or no?
Yes.
All right, I'm going to deny the motion to dismiss for want of prosecution. It's set. I will make a docket note that there shouldn't be any continuances.
Thank you, Your Honor.
Well, Your Honor, will you also clarify the docket control order that they're seeking to have entered reopens discovery entirely?
Well, I don't know what the docket, I mean, I see a motion. It doesn't have a docket control order attached to it. Has anyone looked at this standing pretrial, the standing order for pretrial scheduling?
Yes. Yes, Your Honor.
Is there a proposed docket control order?
Yes, Your Honor. We've been proposing one to Mr. Petard for, I'll just say, several months.
Your Honor, this case was filed as an expedited action and no effort was made to get a docket control order. It went through not only the standard discovery period, but an extension of the discovery period for 6 months. Nothing since then has been done in terms of discovery, except for the defendant's 2 depositions that were permitted by the court to take. after the discovery period had closed, but that was back in 2022. Since then and until 2023, nothing happened. And nothing's happened since then in terms of any
That's
discovery.
not true. I see in October of last year, you were before Judge Gary Gamble. So I've
That's
denied the
2020.
motion to dismiss. Let's get a scheduling order done.
Well, I don't, you mean, are you reopening discovery, Judge?
I haven't gotten to that, Mr. Petard.
okay,
I just,
okay.
all I've ruled on is I denied your motion to dismiss for want of prosecution. You have a trial date for August 19th of this year. So
Okay.
that motion's taken care of. Now, Mr. Hill, you want to show me your scheduling order?
Certainly can, Your Honor. Let's see where I can find it here. All right, we're looking at the latest agreed docket control order that was sent to Mr. Petard.
But
Right.
clearly it's not agreed, or we wouldn't be having a hearing on it.
Right. I'm sorry. I shouldn't say it's agreed. It's the proposed.
Okay.
Just has the standard, all the Travis County type DCO language.
Or entered by the court. So let's start at the begin. What do you object to about this order, Mr. Petard?
I object to all the discovery that he would like to take. I just don't think that should be opened up. He was ready for trial on the 2nd of October. He should be ready for trial right now.
Point me to the rule that I should look at about why no discovery should be allowed.
The 190.2 of the Texas Rules of Civil Procedure govern the date for
I'm gonna grab my book. Keep going. I'm sorry. And 90.2.
190.2 provides that in an expedited action that the trial shall be within 60 days of the close of discovery. Close of discovery was February of 2022.
When was it? When do you allege the close of discovery was when?
I think it was February the 11th or the 13th of 2022.
And point me to the rule about that. How do we figure that out?
Well, if you look at 190.2, the rules for discovery sit there.
I'm looking at 190.2.
I'm trying to get to it myself.
Mr. Hill, do you want to respond to that while we're waiting for him to?
I'm sure I'd love to, Your Honor. So here's the problem with all this. It's this is probably one of, I'm going to say, just over 100, maybe 200-300 cases I've filed in the last, 12 months that are level 1 cases that are subject to this particular rule. Some of those cases were filed even before COVID. Some in Harris County were filed before Harvey. And the issue is that these cases just don't get reached. Trial courts got a bigger dockets. They don't get to them within the 6-month time period that was initially thought by the legislature that the cases could be handled. It just doesn't happen. Not even in the fastest counties like Montgomery County does this happen. So the cases get reset. When they get reset, DCOs sometimes just automatically get generated by courts. And when they don't, the parties agree to them. It's usually pretty straightforward, and I thought it was straightforward in this case, and it hasn't been. I don't know what else to really do at this point.
Have you filed a motion to reopen? I mean, why didn't you do discovery even during COVID?
We did discovery, Your Honor. We've done the plaintiff's deposition, the defendant's deposition, a couple witness depositions. We've exchanged multiple rounds of written discovery. I think I've designated 17 different experts, not all of which are going to testify. Probably only two or three are going to testify. The only discovery that we probably haven't done would be technically a trial deposition of an expert. If they chose not to come to trial live, I typically bring them live. In every case that I've done we'll just say the last dozen trials, I've brought them live. But every now and then, expert says, hey, we're not available to come live. And then we usually just within like 30 days of trial, we knock out a quick trial deposition and then that's it. Sometimes a little farther out, like 60 days. I try to do it as soon as I know that they can't come. But Mr. Petard here is not working with us by any stretch of the imagination.
Well, so you don't need to designate any more expert witnesses, right?
That's correct.
Well, then why don't we put that date has passed?
That's fine with us, Your Honor.
Okay, let's amend it as we go. Or just make a note if you can't figure it out real quick and let you do it. Then what about the
Are you representing the court that you have talked to witnesses about coming to trial? I shouldn't ask you. I should say I don't think that has really occurred.
We've already served all of our 18001 affidavits. There have been no counter affidavits. We can take this off if we need to.
all right, then you can just say date passed, or you make some indication. So Mr. Petard, if that does, we're not going to do any more discovery. We'll just put date passed on that. And the affidavits.
Listen, if he wants to take a deposition of one of the doctors, that's fine with me.
Okay, I thought I heard you complaining about discovery.
Well, if you're going to let this case be tried on the 19th, I know that he's not going to have a doctor who's going to testify as a reasonable medical probability that this injury is reasonably probable because of this incident. I'm very sure of that. So if he wants to take a deposition, we can test that with the doctor in deposition and use that at trial if it's successful for him.
All right. So you allege. So do you think that the deadline has passed for your designation of experts as well, Mr. Petard?
I would think it has, yes.
All right. Well, then we'll put that on the designation of witnesses, experts by defendant, and then your counter affidavits as well, right?
And counter affidavits definitely expired, but I'm not sure exactly what you're saying.
Well, I'm looking at, can you see on the screen, we're amending his proposed docket control order. Can you see that? That's a yes or no question, Mr.
No, I'm not seeing it right now. I'm trying to see if that's something I've done that's wrong here.
Well, do you see, let me ask you this. Can you see anything on your screen? Can you see me or Mr. Hill?
I see you and Mr. Hill and Ms. Bernstein. This is why I think I've just somehow done something weird, but
Mr. Hill is sharing his screen, so I'm having his modify. Well, if you can't see it, Mr. Petard, respectfully, we're 40 minutes into a hearing that was supposed to start at 2 o'clock. It didn't start for half an hour because of your technical issues. So we're going to go ahead, or you're going to reset. What's your preference?
I'd like to reset.
Mr. Hill?
Your Honor, I mean, first he didn't, I'm just going to ignore all of the just not working with us on just the DCO or trial date or anything discovery related now at this point. I'm going to skip all that and I'm going to get to this hearing here that he wanted to set. And I said, please don't do this. The last 3 summary judgments you've done have been a waste of our time. You've done an improvisation. And at this point, I've given you all of my medical records. I've got expert designations. We've got photos. We've got witness testimony.
Hold on one second. Mr. Petard, can you now see the screen?
I can, yes.
All right, then we're going to continue with this DCO. And all right. So what plaintiff's deadline to amend or supplement the pleadings? Do you have an issue with that, Mr. Petard?
Yes.
What's your issue?
The issue is that it's changing the date of the injury from the date that has been presented from the word go on answers to requests for disclosure.
This is supplement. Hold on, Mr. Petard, this is the plaintiff's deadline to supplement or amend their pleadings.
Okay.
He proposed is July 19th of this year. What is your issue with that? It's 30 days before trial.
I guess I don't have an objection to that.
No, because that's the rules of procedure. The next deadline is defendant's deadline to amend or supplement pleadings. July 26th. Do you have an issue with that?
No.
Deadline to join additional parties. It's passed. Well, we can leave it February 21st, so do you have an issue with that?
No,
All right. Mediation, which is required under the local rules.
It's-
Unless and until somebody files a motion to waive mediation. That's not before me today.
correct.
Do you have an issue with the date of June 20th that you're required to mediate?
No,
Do you have an
Well,
issue?
as long as that's not a concession that I'm waiving a motion to skip it, but I don't have a problem with the date. No,
All right. End of discovery he's proposing is June 20th.
I don't have objection to that.
Dispositive motions must be filed by June 20th.
No objection.
Challenges to experts by July 19th.
That's fine.
Trial witness disclosure and trial exhibits under 30 days before trial.
It's fine with me.
Deposition designations 12 days before trial. That's according to our local rule. Motions in limine, 10 days before trial. 6 days before trial. Objections to deposition designations, cross designations, and a jury charge. Have any objection to that?
I don't have any objection to any of those.
Do you have any objection to any of the rest of this?
I don't think so. I'm on page 3. Okay, that's all. I don't.
All right, Mr. Hill, you may send that to me and I will sign it. I will grant plaintiff's docket. Plaintiff's scheduling order is approved.
Your Honor, as far as sending it to the court, what's the best method?
To my submission email address, which is x.gov. You're supposed to reference the cause number. Please say it's from today's hearing.
TravisCounty.gov, Your Honor.
Yes.
And if for whatever reason mine doesn't go through, Shelby here at my office is a little better at that than I am, and she'll get it to you today. But I'm gonna try right now.
All right, thank you. So now we've taken care of the scheduling order, the motion to dismiss. What's up next?
Motion for summary judgment on the basis of no causation evidence.
You want to proceed?
The requirement for proofing up causation of anything that is beyond the layman's knowledge is that an expert must do that. There's no testimony by an expert that would do that. This woman's injuries that she was treated for specifically, she has, first of all, a surgery on this knee back in 1996, same area of the knee on the meniscus. The records of the doctor's operative notes indicate some of the repairs that he was doing were with respect to an old injury. There's no distinction between that and anything else that he did that says that this was caused by a fall or recent trauma. Second, she had subsequent to that this injury was sometime in July of 2020. After months from her surgery, then was around the end of July. In late 2020, she went to see other doctors, and on one of those doctors' notes, they indicate that she had an acute.
Can I stop you for 1 second?
Sure.
Is this the same summary judgment that was ruled on by Judge Garrett Gamble and is the subject of your November 16th, 23 motion
No.
for reconsideration?
No, this is evidence, lack of evidence.
Is it the same basis upon which Judge Garrett Gamble denied your earlier motion for summary judgment?
No.
Go ahead.
Okay. All right. So the medical notes from her doctor that did their knee surgery 6 months after the date of injury, approximately, indicate that she had a twisting injury, acute injury on around December the 1st. Later, they did this knee operation on her. They let that settle down, they said, something like that. And then their notes say that the cause of her medical condition was arthritis. They don't say anything about a fall. Nevertheless, it is their medical expenses that are added to all the others. There's no distinction by any doctor as to what is due to this injury, what's an aggravation, or what's not even an aggravation. The only information that we have are medical records where the plaintiff said that she fell, and I think she said she struck her knee. She said in her deposition she didn't strike her knee. She said in her deposition she didn't know when this happened, but she said in her medical records that it happened on the Monday following the date of injury, according to the latest amended pleading, which says that her date of injury was the 17th. So on the 19th, on the 20th, Monday, she told the doctor that it happened on the 17th, but the next day she went to get an MRI and she said it was on the 19th, which would be Sunday. Just because the medical records indicate that she said it happened when she fell, that's not medical record. That's not evidence of admissible evidence that it's a reasonable probability, according to this expert, that her complicated, beyond the layman's knowledge, information about her injury was related to this fall. There's no distinction between ruling out of other potential causes, such as pre-existing injury, such as potentially fraud, which I think is evident in this case. And further, okay, I think that's sufficient. So there's just nothing. Mr. Hill can speak for himself, but his indication to me is that he thinks that just because something is mentioned in a medical record, that is a scintilla of evidence. I don't think it's a scintilla of evidence.
Anything further, Mr. Petard?
That's it.
Mr. Hill?
May I share my screen, Your Honor?
Yes, you may.
All right, Your Honor, what I'm showing the court is the plaintiff's response to this particular motion for summary judgment that was filed by the defendant in December of 2023, which, although similar to the preceding motions for summary judgment, this one just specifically stated that it was as to this element of causation, which is going to be an element of plaintiff's claim. It's any negligence claim. This is a personal injury lawsuit. This is a premises lawsuit. That's what we have here. And so the standard under Rule 166AI is that the plaintiff is required to produce more than a scintilla of evidence, some evidence, not have to prove your case, but some evidence. And as a reminder for the court, we don't have to have doctors testify before we come to trial. Sometimes that's helpful. Sometimes that's convincing. Sometimes that's even more convenient than having them come to trial. But I like them to come to trial. There's nothing that says that they can't just show up to trial. The case law on the issue of causation, as far as experts, if it's outside the common knowledge of of a juror, the Guevara versus Farrar, the Hills v. Donis, even the Sosa versus Montgomery County cases, those cases may or may not be controlling here on a particular issue or be on point. But the court can rest assured, as far as experts go, they've been designated by the plaintiff for many years in this case. They've all been designated, and some of the ones that are required will come to trial to testify. I won't try a personal injury case without a causation expert. Here we go. The evidence that we have, we start at Exhibit 1. We go through all the way Exhibit number 8. 1, we got photographs of the right knee injury. 2, the location of where it happened, which is a stairway at the defendant's residence, or not residence, we'll just say property. Number 3, the affidavit of the plaintiff that was attached to an old summary judgment, I'm going to say maybe in 2021 or so. The deposition excerpts of Heather Downing, the plaintiff. Medical records from just 3 that I handpicked out of several that she has that have all been disclosed under Rule 194.25 designations, as well as all the records that have been produced to the defendant in this case, none of which have been controverted. There's no defense medical experts. There's no defense experts of any kind. I did the latest disclosures, which were served back in 2022, that all had plaintiffs' treating providers designated as non-retained experts. They've all been on there. The reason that it's amended 9 times is because anytime there's new evidence, I amend it and keep it up to date. If you roll down, we've got photos. So Exhibit 1, we've got the right knee. That looks like it's pretty damaged. That's some evidence that she had damage to her right knee. We've got more
And
photographs.
she has deposition testimony that she fell on the stairs and damaged her right knee.
Not only do we have an affidavit, we've got deposition testimony, Your Honor. Going up or down? Down. And where were you in regard to these staircases? Answer, you called the upper stairs set. I was going down where the handrails are on the right side. She explains it. He took her deposition. We keep going. We got medical records. New guest, and this is on right here, visit 7/20/2020, 3 days after the incident. Date of incident, 7/17/20. Location, interior, disusely around the knee, aching sharp constant, right knee injury.
I've looked through your response, I see. So
I'm going to go ahead and stop sharing, Your Honor. I can keep going. And this is-
Your Honor, none of that is an expert's testimony that this injury, which we admit she has an injury, but there's nothing that says that she has an injury as a result of the fall that she claims on various days. And that's what's necessary, because this is beyond the ken of a lay witness. This is
Picard, I've looked at this. Your motion for summary judgment is denied. What else do we have?
motion for sanctions, discovery abuse.
What day was that motion filed? Because it must have been a long time ago. I looked back several months and couldn't find it.
I'm I could be assisted if I had see, I'm working with two computers here. It's kind of hard, but if you give me a chance, I will find it.
Do you know, Mr. Hill?
I could see if I can pull it up for everybody, Your Honor.
I found it. It's filed on 9/14/23.
Okay, great. Your Honor, whenever this accident happened, and she says the 17th, so that's a Friday. 2 days later, she went to the lake with a friend who joined two other people on a boat. And I've got an affidavit from one of those persons that says that she didn't seem like she was injured on the boat. She says quite differently that she was very injured. She had to be helped into the boat and out of the boat. We want to know who those other two people are, and they refuse to provide that information, even though there are people with knowledge who should be disclosed.
Well, shouldn't that be a motion to compel?
It should, it could be, but I had his in the time leading up to the end of discovery. He agreed to. Now, I could do a motion to compel now, but I thought that taking any action after I filed a motion to dismiss for warrant of prosecution was inconsistent with that position. But we have been to court before, and while that wasn't the subject was opening up the discovery for two witnesses, which we did take. The judge did allow that. And in that discussion in front of the judge, Mr. Hill said he would give that information to me. He just didn't know what I wanted. Well, he did know what I wanted, and I showed him that by his prior conversation with him. But he certainly has known ever since, and he still refuses to do that. He refuses.
Do you have a proper discovery response? Do you have a proper discovery request?
Yes, I've got. Well, that's the request for disclosure, and I've pointed out to him many times. Look, you don't get to not name them just because you're not bringing them. If they hurt you, they still have information. I'm still entitled to know who they are.
Okay. How is it that you say there's someone who would testify that she wasn't hurt? Where did that come from?
Well, first of all, there's the woman that was on the boat, whose name I do have, whose affidavit I've got, who said she didn't see her as behaving in any way like she was injured, whereas the plaintiff's apparent condition was such that she could not bear weight on that leg. So that's totally contradictory. Second, the next day, an hour before she went to the orthopedic doctor who did the surgery on her, she went to a pain doctor for her neck. And the medical records of that examination said She's normal gait. She doesn't have any other problems except the problem she's complaining of, which is her neck. Within an hour or even less time than that, she goes from that doctor to the orthopedic doctor's office where she was examined by a physician's assistant, and she can't bear weight on that leg at that point in time. That's within an hour. So yes, I have some evidence that she was fine up until she walked into that orthopedic doctor's office. And when she walked into his office, she suddenly couldn't bear weight. She was in such pain. So I want to have these other two witnesses, because one of them was intimate enough with her that he spent the night. And he's never, I think I know who he is, but I'm not positive. I certainly don't have a way to contact him and subpoena him, but he's in San Antonio. And as far as I know, that's where he was last. Why can't I know who would know what her condition was after the point in time in which she said she was injured, when another witness says she was fine?
Mr. Hill.
Honestly, that's hard to follow.
I agree. It was very hard for me to follow too.
If there's a discovery request that I have not responded to, then it just needs brought to my attention, and I'm going to respond to it to the extent that we can. As far as disclosures go, I can vaguely remember a series of phone calls or emails or something from Mr. Petard, maybe even brought up at a hearing kind of like this, where he talks about these folks in this boat. And during the deposition of the plaintiff, I think she gave, and I'm looking at it here, the names, partial names. There's Sterling Dixon, who he's talking about. She gave a name of, let's see here, Mizia, which is spelled Mzyaa.
That's the person I've talked to. I've got her. But the other one, she identifies as somebody like
Mr.
Mike
Petard,
Garcia.
it's
Yes.
not your turn yet. Mr. Hill
Sorry.
is responding.
Sorry.
All right, so the Mizia last name is Garcia, which he just said he already knows who that is. There's also a Tommy, and she thought the last name was Garcia, and she said that it was, those folks are from San Antonio, and that's what she gave to him. And I don't know what else I'm supposed to do. Like, I've asked her, she doesn't know. If I've got people that have knowledge of relevant facts that I could identify and disclose, then we would do that, and that's what we always do. We've already deposed. I think what he's talking about too is I want to say we've deposed 2 additional witnesses that Mr. Petard thought that saw Miss Downing sometime after her injury or before her injury, and testified to the effect that she was drunk and that she wasn't that hurt, and that really she probably fell down the stairs because she was drunk, and there was some boating incident. We've been down this road.
May I respond?
You may.
First of all, that's really disingenuous. We've had emails such that Mr. Hill has said, I don't know what you're talking about, and you're a bad lawyer. And he told the other judge he would identify these people if he just knew who I was talking about. And I sent him an email showing him the emails that he sent and that I sent to him, where I said, these are the people I want to know. And his response was, we've done what we think we need to do. In addition to those people, I've asked for the psychiatrist and the chiropractor that were treating her at this same time period, and I've never received any medical records concerning them.
All right. I find I'm looking at your motion, Mr. Petard. I think it really should be in the manner of a motion to compel. I find the argument hard to follow. And so I'm going to deny the motion. Anything further?
Does that foreclose filing a motion to compel? Because I can make I can make a motion to compel, and it will not have any confusion in it if you think this is confusing.
No, I'm not. I'm just ruling on the motion that you have filed.
Okay, fine. I understand.
Anything further?
There's nothing further from the plaintiff, Your Honor.
Mr. Hill, I need you to prepare orders on the denial, and it could be one order, denial of the motion to dismiss, denial of the motion for sanctions, denial of the summary judgment filed in December of this year, causation. Send those to Mr. Petard for agreement as to form. If y'all don't agree, I want them sent to my submission email address, and I will, all right. By a certain day, well, I want, if we can't get this done by, a week from Friday, then we're gonna, either you can agree to have me do it on submission, or we'll set a motion to enter.
All right, Your Honor, I'll get that done. And it'll be sent to him no later than I would say tomorrow morning by 10 a.m.
All right, if we haven't, so we have settlement week next week. If, when we get back from settlement week, I don't have these orders entered by March 18th, my staff is gonna reach out to y'all. I'm gonna set you for a motion to enter.
Thank you, Your Honor.
Anything further?
I have nothing further.
Mr. Hill, anything further?
Nothing further from the plaintiff, Your Honor.
You know, I'm happy always to let people have hearings remotely, especially if it keeps people from traveling. It helps the environment. However, if we're going to do it again, I want everybody to test their technology before we get started and make sure that you're able to log in and that you have computers and whatnot, and you're near enough your router. Because today it didn't matter if I'd had other people on my docket, I just would have passed you. Because 30-minute delay in getting your technology set up is not acceptable. All right?
All right, Your Honor. Thank you very much.
Thank you. You all may be excused.
Appreciate it.